All right, thank you. A couple of weeks ago when I got a call from Leona, they asked me to be on a member of a panel. So I said, yes, I agree to do that. And then I looked at the agenda, and I saw my name listed, and I didn't see any panel. So I'd like to introduce my panel, and that's empty chair number 1, empty chair number 2, and empty chair number 3s and 4. So anyway, and I don't hold grudges, so, you know, we'll get over this. One thing before I do start, Jim talked this morning about deficiencies and pass with deficiencies. And he mentioned about how Bob Brooks thought that up. And he said there was another Bob in the room that didn't particularly care for it. Well, I'm the other Bob in the room that didn't care for it. And the reason being is that, to me, deficiencies, by definition, includes failure. And I don't see how you can have pass with failure. And so one of the thoughts that I had at one time was to use the word condition, because if you look up at the definition of condition, it includes let me just get here. Conditions, because the definition includes liability which terminates or halts the performance of a duty. And I think a condition is more appropriate. And I'm looking at that from the profession side. As a CPA, I would much rather have a report that says passed with conditions rather than passed with deficiencies. I lay that out there. I don't make any further argument over that, but it's just something that's bothered me for a long time. Okay, and then you gave me the microphone, so that's what happens. All right. This is going to be an open discussion. It's going to be an open discussion of what we can do with failed reports, or what we should do or not do. Maybe we don't do anything with failed reports in themselves. Maybe we do. And what I'd like to know is that, just to get an idea, and we could all look around, like, how many people are sitting members of their, current sitting members of their state boards? Just raise your hands. Keep them up for a minute. And take a look around so we see that. Okay? How many people were former board members? Okay. Only a few there. Okay. Now, how many people are members of a peer review oversight committee? Okay. Okay. So it's about equal. It's about equal between current board members and people on peer review oversight committees. Okay. There's going to be a discussion. It's up to you. I've only got a few more words to say. We're going to open this up, and we're going to see where we go with it. But when you do speak, I'd appreciate it if you'd give your name and the state or organization you're with. If you're a board member, just say your name and that you're a member of the board, so that we can see what flavor we get and what direction we're coming at, because we may not all be coming at it from the same direction. I also want to just comment on the fact that I think Jim Brackens this morning made another great observation, or at least when he said failure versus failure to remediate. And those are strong distinctions, which I think in this discussion that we're about to have, that we have to remember. There's failure, and then there's failure to remediate. Two completely different, not completely different, but they're different. They're much, not the same, put it that way. New Jersey has a peer review program. It's took a long time to get it adopted. The rules, we struggled with the rules for a long time because of the cooperation that we weren't getting from other parts of state government. But it did get passed. It did get approved, and it's in existence. What we're trying to do is get it up and running. We're not there yet. We're in the earlier stages. So a lot of what we discussed today is going to be very informative to the people from New Jersey. Our program takes failed reports And if you fail twice, you're in an accelerated review within 18 months. That's the way the regulation is written. I'm just giving you what we have, just to throw out a position. What happens that if you then, after that accelerated review, if you get a pass with deficiencies or a fail, then the board steps in. The board shall conduct a review to determine whether the firm may complete a test engagements. In other words, you're in the board's grasp at that point. Okay, and also the board will determine whether or not you have to get pre-issuance review or whether or not you're going to have to refrain from doing certain types of work. So that's how New Jersey, that's where they are. I'd like to get a discussion going now, if you will, as to what should we do with fail reports? What, you know, and at what point should the board step in and take action? Anybody want to open it up? I knew this was going to happen. Told you it's going to happen to me. Where are we? Raise your hand. Oh, all right, go ahead.
Whoops.
Lady back there, in the last row.
So it's something, I'm with the California Society of CPAs, and it's something that our proc is considering and everything. They don't, and I like what you said. I also like Texas, where they look at the second pass with deficiency and or failed, and then evaluate it. The problem I have is if it's the first peer review and they get a fail, that they aren't sometimes it seems like the boards are interested more like protecting the public. They'll come in then, and they don't give the program time to work, or for the education and remediation part of the process, and that's of concern to me when that's occurring.
Okay. Anybody got a response to that? Anybody want to make a comment?
I want to address that because we did receive from the California PROC their guidelines for what they are doing on failed reports, and at least what information they provided to the Compliance Assurance Committee, and I hope I get this right. If I don't, I'm sure that I will get confirmation from someone in California. But the way I understand what they do is that a first failed report, they do look at all failed reports. On the first failed reports, if it's not egregious, they don't define egregious, but I'm reading it to mean lots of problems, as we discussed earlier in the breakout session that I did, that if it's not egregious, they do not take action. But if it is a second failed report, it does go to their enforcement area and they review it. Now that's just the gist of what they do. So.
Is that a second consecutive fail report or just a second fail report, whether there's 2 or 3 in between?
Well, that's a good observation.
I would think it's consecutive. I believe it is consecutive based on what I've read. Maybe just a show of hands might be helpful for those of you that are here representing your jurisdiction. If you know what the board does on failed reports, a show of hands, if it is consecutive fail, consecutive pass with deficiencies, could you raise your hand if that's when your board deals with it, is only when it's a second fail or second pass with deficiencies? Okay, so I'm only seeing one hand go up. I know in Oklahoma that's primarily what we do, is that it's 2 consecutive. So I presume they could fail, pass, fail again, and it would not immediately necessarily go to enforcement. But I think I think our PROC would look at that and go, well, gee, what happened? You know, what happened? So did you have some comment, Alan?
I'm just going to say we just have started looking at these in Kentucky, and we're looking at the second PWD report or the first fail report. Now, Most of the ones we've had so far have just been engagement reviews, and we've looked at them, and that's all we've done. We did have a system review back early on that was a fail, or it may have been a second pass with deficiency, and the firm was wanting to just not do anything with it. They was going to fix it on the next engagement, and we did require them to go on and fix the problems because it was a yellow book engagement, a GAO engagement, and we did require them to fix that, and our investigator look at what they had done in order to fix that and reissue the reports with regard to that. We did not fine them, we did not do anything else, but we wanted them to understand, especially on Yellow Book, that they're expecting those to be fixed and not wait until the next engagement. They look at each engagement on their own, and this comes directly from some conversations and classes I attended with some GAO representatives, and they do expect us to go and fix those. So as a board, we decided to have him fix that. Punitively, there was nothing else that we did, though, as far as from a restriction or fine.
I just have a response to that. That's more engagement oriented, and on a fail, aren't you saying that the system has failed, and it represents itself in substandard work in engagements? So it seems like you're centered on the engagement, Alan. I'm not taking issue. Well, I am taking issue with it.
I think it was the second pass with deficiency report, and because it was, it was identified that it was a yellow book because the peer review reports now identify that, and that's where all the issues were that was in that pass with deficiency. We did require that engagement to be fixed.
Anybody else got a comment on anything about that? Okay. All right. What about comment on the fact that Minnesota? Where you go? Oh, I'm sorry. Go ahead.
Well, I had a question about the process that was just described and whether or not requiring that be fixed at that particular engagement, wouldn't that have been, from the PROC's viewpoint, a failing of the RAB process itself? Because wouldn't the RAB have required that be fixed if that was something, or are you overseeing the engagement, or are you overseeing the process?
Is this on? Okay. I'm going to give you what the current situation is and where we're trying to move. We have been told that in terms of the AICPA, that we cannot legally make a firm do anything. Okay, a board can. So what Alan was talking about for the board, I completely applaud. They have the legal ability to require that. What our guidance is, and Sue Lieberman over there can correct me if I say this wrong, but we're putting in very strong guidance to do whatever we can to strongly encourage firms to do that. Because because Alan's right, when you're talking about A133 filings on the clearinghouse, you can't say it's going to be fixed the next time you can't. That's being relied on for a lot of reasons, and it has to be fixed. You either have to perform the omitted procedures, recall, reissue, whatever the case may be. But we cannot legally tell a firm they have to do it. What you will see or should see is some pretty onerous remediation for those firms, like extreme oversight. That's what we're really trying to move the RABs to do, because but we cannot legally make a firm do that.
Well, I just would like to follow that line of thought a little further then, because you may not legally be able to require the firm to do it, but you can decide whether their corrective action plan is appropriate and whether or not to accept their report as filed.
You've just hit the discussion point I've been trying to have the board take in the position I would personally like to see. That is a debate, though, as to whether we can go to that point and say it is not an appropriate corrective action plan and not accept it. Sue, am I saying that right? And that's part of the discussion.
What the board is looking at is, they are taking this very seriously, and we have not been able to require a firm to recall a report. But what we are going to provide is guidance to the RABs that in addition to a corrective action, that they should require the firm to provide some type of evidence of what they're doing to correct that non-conforming engagement. So it'll be in addition to a corrective action that's being placed on the firm.
But the question, Sue, is one of the considerations being given that if the, and I am speaking specifically to A133, that where it's clear that the only appropriate corrective action is reperformance and the firm does not do it, that the RAB will not accept the firm's response, saying it's not responsive and in essence not approve the review. That was the question. Is that being discussed by Standards Task Force?
I'm not sure with regard to A133. This all started with A133. I'd have to check to see what's going. It's going to the peer review board in August, so I'd have to double check. I can maybe do it during the session and get back to you on it.
I have a question then, Jim, and how long would that process take, do you think, between the time there was a disagreement and the time that the final report would be issued? In other words, what kind of a timeline would we be talking about? You go into a firm and you say, okay, we think you should reissue, and they don't want to reissue. Would there
Bob,
be a completion of a report at that point?
Bob, what you're going to, it could take a long time. I mean, it really depends. I mean, it really depends. The better way I'd rather answer that is from a monitoring perspective from a board. You know, particularly if you're following FSBA, you know, you can see, you know, when the firm's last peer review was and when another one's due. You also should be able to talk to the firm where they may have a requirement for, you know, an extension of time. You know, there's inquiries that the board could do to see, you know, why. I mean, you know, the administering entity can't tell you what's going on or why, and then, yeah, it could take some time if you get into a serious disagreement.
That's what I'm trying to get at. Is that what idea would a board have? In other words, yes, they got a firm out there that's undergoing review or a peer review, and they're supposed to have it done by a particular date. Would you anticipate that extensions would be granted or not granted during that period?
Well, bear in mind, the extension is time to get the report and the work papers to the administering entity. I mean, that's what the extension of time is. It's not, you know, that's what's, I'm saying it right, Paul?
Go ahead.
You know, beyond that time, it is not, you know, it's the firm is not being late at that point. What if the firm is not being responsive? We have a procedure for going after a firm for failure to cooperate in the process and ultimately kick them out. And again, that's why we talk about procs. That's the reason for having a PROC, so that they're observing that process to make sure that we are sticking with the firm, we are following up and making sure that if they're not responsive, we start taking our process to kick them out. But, you know, there really is no transparency of that going on at the time.
Because what I'm looking at is if there's an oversight by the board, at what period might they want to step in and ask what's going on? And you know, if they're looking for a report, I'm not verbalizing it as clearly as I would like to, but if you had a firm that's out there and they've got a dispute going on administratively, if you will, I didn't know if there was a particular time period that could occur, would occur, or should be completed by. Because at some point, somebody has to pull the plug someplace and say, stop.
That's, you know, again, maybe Collins over there, I don't know if I've not to put him on the spot. I don't know if Oklahoma's looking at this or not. But I mean, this is where clearly a board can be monitoring when they would expect to see, you know, a peer review, you know, acceptance letter. And if it's not there, you know, that is appropriate time for the board to be reaching out to the firm and saying what's going on. You know, why, you know, the firm can tell you, and the firm can give you permission, grant permission for you to talk to the administering entity. Paula, well, it's not an issue in Florida yet. I'll pick on Linda McCrone over there. Once Linda gets permission from the firm, she can talk to the California board all day long about what the particulars are. But the firm would have to get permission. So if the board is monitoring it, sees that they should do it, and the firm says, go talk to Linda, and here's my written permission, Linda can explain what the situation is.
Okay, okay. Any comment? Go ahead.
You had alluded to single audits and findings. Are boards typically having a higher standard for so-called must-select engagements, single audits, employee benefit plans? You know, for example, the first pass with deficiency on a single audit or employee benefit plan is looked at more carefully than firms doing other types of attest work.
You're asking me that question?
I'm putting the
I'll tell you what I would anticipate in New Jersey. I would say to you that New Jersey, as I originally thought of the program in New Jersey, and I'm not saying that that's exactly where it's going to head or it's not going to be modified or changed, but as I originally, and I was the chairman of the committee that was there when we got the regs put through and adopted, so I can't say I'm an expert on it, but I had some knowledge of it. That wasn't going to be a board call. That was going to let the program and let the AICPA and the State Society run the reviews and do the work. And if they felt that that should be done, they should be done. I never anticipated reaching down into that level to take the program away from the administrating agency. Now, I don't know whether or not, maybe that's got to be rethought, I'm not sure, but that was always my intention, was to let the AICPA do what they do, just monitor their overall program, but not reach down into the individual reports as far as to pick and choose as to what. Sit in on a RAB, yes, look at a RAB, but not in any particular RAB, not any particular firm's work. Was to look at the overall program and let the program function.
Bob.
So I mean, that's, at least that was always my thought. Go ahead.
Am I on? Hello? Okay, there we go. I
talking
think the
into your
question that you're asking is, should the board take a different action because it's Yellow Book or Department of Labor? Is that, am I hearing the question correctly? So you're talking an initial pass with deficiencies? An initial pass with deficiencies. Is that what you're asking about? First time?
Yeah, for example, because I think
Okay.
it was mentioned earlier that the second pass with deficiency was a standard somewhere, but I'm saying would a Yellow Book or Department of Labor, would you be more concerned about that because it's so-called public interest entity or must elect?
I think the board should have the same concern irregardless with any pass with deficiency, whether it is Yellow Book and Department of Labor or whether it's audits of business entities. And I think the key thing for your enforcement area to look at is whether or not that firm has been responsive to the follow-up action. In other words, the firm was required to do CPE and maybe pre-issuance review of their next Yellow Book engagement. I'm just giving some examples. That may be overreaching on a pass with deficiencies. That may be more than would be required. But if the firm's response, and we see this a lot of times, or I do in doing peer reviews, I will usually tell the firm when I'm doing the peer review, hey, you're going to have some CPE and documentation or disclosure. I know that's coming for you. So a lot of firms will immediately go out. They will have already taken some action. That is a firm that's very responsive. As a board member, I'm going to be more comfortable that that firm is going to fix their problem. Now, sometimes you get letters and the letters of response from the firm and you can look at them and tell they don't have still a clue about what they even did wrong, much less what they've been asked to do. So I think it's a case by case. We do need to allow the program to work. So I'm very reluctant, I would be very reluctant as a board member, this is just personally as a board member, I would be very reluctant on an initial pass with deficiencies where certain corrective action has been prescribed and the firm has agreed to do that, not to allow the process to work. Now, if the second time comes around and that firm gets another pass with deficiencies and it's to do with Yellow Book, my opinion would be very different. That's just kind of what we followed.
And presumably your feeling would be very different if, as a point was made, that they failed to remediate, correct? Or didn't,
I think
if the
that-
firm responded, then we
I
let the
think that
process work.
particular issue that Alan was discussing was a failed report, wasn't it?
It's either fail or a second pass with deficiency.
So
That's the only one we see.
what Alan is saying behind me is an initial pass with deficiencies their board would not see, and we would probably not see in Oklahoma either. Texas, would you all see an initial, your board would not see an initial pass with deficiencies? Maybe a show of hands, if you know in your state on a pass with deficiencies, I know this is about failed reports, but on an initial
That's all right.
pass with deficiencies, would your board take action? Or would they even see those reports? No hands?
New Jersey's going to see them all.
New Jersey's
New
going to
Jersey's
see them
gonna
all.
see pass, they're going to see pass with deficiencies, and they're going to see fail. Because every firm will submit their report together with any letter of comments and any other correspondence that related in there to the report. So if you, and you have to file that shortly after you get your peer review's been completed, and you get that. But if you get a peer review report, we want to see the report, we want to see the letter of acceptance. If it's a pass with deficiencies, we want to see the comments back and forth, and again, the letter of acceptance. And if you fail, we want to see that report. So all those reports will be submitted to the Board of Accountancy. They're
But-
going to take those reports, and they're going to, there's, in the database, we have the ability to record against each and every firm details concerning those reports, when your peer review is, what year do you have, or what's the month and year of your peer review.
But the board itself would not see those reports. They wouldn't come to you as board members. That would be the admins would see all
They
those.
would be submitted to the board. The board itself, right, the overall board would not see those.
Because our admins
I'm
see every
sorry,
one of them all
That's
over.
true.
Okay.
The committee would see them,
Right.
but they're going to be entered into the state's database. And
Yeah,
then
that's my question, which is, literally, what are you saying when you say that the board sees PWDs or fails? I mean, are you talking about staff? Are you talking
All
about
right.
the board?
All right,
Are you talking about
both.
individual
All right.
reports? Are you talking about a summary? What do you mean?
Good. They come in, staff has them, staff will sort them out, and then the information will be entered into the database. The committee consists of 2 board members and then 3 or more non-board members.
But they're already
So-
in the facilitated state board access report. So when you say they're entered into the database, is that a separate database?
It's, it's not online. You can't see it, but it's a database that's available at the board, at the state offices. It has each and every firm, and then there's how do I say, you can scroll down to sub-screens to enter the information, and we've set it up to where that's gonna house and accept the peer review report information.
That's, Bob, that's a system that you all have in-house
Right.
in New Jersey.
Right.
That's a system
Right.
they're using.
So you're not using the FSBA?
No, it's in-house at the, in Newark.
And then do you?
I mean, in Trenton, but it's in New Jersey.
So then, I'm sorry, then do you bring a summary to your board meeting? Or,
No, it'll be handled in committee, but the committee will function. Now, when I say it would be reported to the board, it's reported to the board, but the committee of 2 board members and the other non-board members, they review that information. It won't go back to the board at an open meeting or a public meeting, no.
It's their peer review oversight committee,
That's
basically.
what it's, yeah.
It's
that's-
their peer review oversight committee.
Okay. But I consider that part of the board because there are board members on that. Right?
Thank you.
Okay, what else we got? All right, go ahead. Oh, I'm sorry, go ahead.
I'm interested to know whether any of the state boards have set any written policies as to what should be done on second fails, consecutive fails. You know, it's hard to look at things on a case-by-case basis in those issues.
I can tell you in Oklahoma what we do. On a second fail, that's going to come to the enforcement committee, and then the enforcement committee will have to make a decision on how that's handled. We recently handled one, so I can give you a direct example on what we did. The firm had a peer review and failed. They had a second peer review and failed. And so we have written into our rules that we can send an investigator to investigate. However, in this particular case, the gentleman had already agreed not to perform any more audits with the society. So what we did, because he had two fails and both of them appeared to be egregious, he was offered an administrative consent order with a $10,000 fine for substandard work. And the costs were very low because the costs were basically what the attorney had to do to prepare the ACO. And if he did not accept that administrative consent order, then it would have been set, we would have sent an investigator, had a trial. I mean, at that point, for a firm to go through that is, they're really, that's kind of silly. For one thing, generally when we offer an administrative consent order by the enforcement committee, the fine is pretty much a kind of a standard fine. But if it goes before the full board, there's no telling what the board might decide to fine them. Plus, they've really increased their costs. And he did accept the administrative consent order and signed an agreement. He will no longer do audits or reviews, and if he does, he must have a show cause hearing to tell us why we should allow him to do that again. Now,
What's the composition of your enforcement committee?
the vice chairman serves as the enforcement officer, plus one additional board member. So there are two board members.
In Texas, firms that have two consecutive either fail or pass with a deficiency or combination of go their firm information with all the supporting letters of comment or FFCs and reports are sent to the peer review committee of the state board. And at that point, and it's written in the rules that firms that have two consecutive less than pass will be considered for having an accelerated review, which must be a pass report, or the board can consider suspending their ability to issue reports on financial statements.
I used Texas as a model when I was putting New Jersey's together, and Ted Tracy was a big help down there with that, and that's why it's similar. It's similar, not exact, but similar. All right. Has anybody else got any thoughts? All right. Go ahead.
Hi, I'm on the peer review board committee for Arizona. We're charged by the main board to come up with a policy for consecutive fail or pass with deficiency reports, and I want to know if some of this information, maybe Texas or New Jersey, if that's available somewhere for us to look at.
New Jersey regs are on the website, and so are Texas. You can go to the Texas, just scroll back. You can steal a lot of information from them. They're really terrific. I did. And ours is a little more difficult to find, but if you go to the Department of Consumer Affairs, it's under the Attorney General's office. Go to State of New Jersey's website, go to the Attorney General's office, go to Department of Consumer Affairs. Under Consumer Affairs, you'll see accountants. Go to accountants. There's about 5 or 6 different categories that'll be listed there. You just got to fight your way through till you find the regulations. Just stay with that website and you'll find it.
Or you might get a card from Bob and he might send you that link.
I just don't have it in my head. You know, if I did, I would. But I don't know whether it's .us, this, whatever. Heck, I don't bother with that. Just put in State of New Jersey home site, and follow it through. But it's under the Attorney General's office. It's under Department of Consumer Affairs. You'll find accountancy, and you stay with it. Go ahead. Who was
Bob,
it?
I have a question for those who are evaluating the consecutives and wondering whether or not you look at the reasons for the deficiencies to see whether or not they fixed the first problem, but then ended up having a second problem that was unrelated to the first problem, thus showing that they did remediate. Does that come into any of the decisions that are made with these?
Yes, absolutely. In some cases, the peer review committee decides not to require an accelerated review for exactly that reason.
Okay. Also, I just wanted to update you on the previous discussion we had with regard to the non-conforming engagements, and I'm looking at the draft guidance that we're proposing to the peer review board next month, and basically, the team captain needs to remind the firm of their obligation and consideration of the recall and reissue guidance. And based on the firm's decision, the team captain will make a decision as to whether or not the firm is taking the appropriate actions. If they are not, for example, if they have an A133 engagement that is completely blown and they don't care about it, then the team captain needs to consider whether or not they have a tone at the top deficiency. And then when it gets to the RAB can also make a second decision on whether or not they're comfortable with what the firm decided to do. If they are not comfortable with it, then they can defer the review for further information on what the firm intends to do with this. And if the firm still decides not to fix the engagement, or the reviewer does not put a tone at the top deficiency in the report, then the firm will probably go down the path of non-cooperation and thus go before the peer review board and possibly get terminated from the program.
All right. Go ahead. Another comment, because then I got.
So I just have a question about FSBA. Does FSBA have 2 periods in it for like going to the second fail and everything? Do you know how FSBA works, Sue? Does it, the facilitated state board access, does it have 2 periods? Because if state boards are using that, they would need to have both the current period and the prior.
Those of us who use it daily would like to see 2.
Okay.
We've talked about this. We've heard the request.
The request has been noted, and, you know, I don't know if it's been further discussed about or not. I know it's been, you know, it's something I would like to see us be able to do as well, yeah.
All right. Give her a mic, please.
What the administrating entities are supposed to be doing with consecutives is mandatorily sending a warning letter to those firms indicating that you could possibly, if your next peer review report is not a pass, that you may be deemed as not cooperating. So maybe that letter could be something that is placed in FSBA.
No.
You'd have, no?
No,
You couldn't do it as a, okay,
no.
sorry.
Come on, Jim.
Let me just add something to this, and then I'll confuse it even more. If you go back to the original quality enhancement program, the original quality enhancement program was nothing but educational and remedial. And there are some of us that remember that, and then, and felt very, very strongly about that the program not be used as a club, that it not be used for disciplinary purposes, that it was to bring the level of performance up, to raise it, not to go in and take licenses, not to fine, not to discipline, not to sacrifice licensees. Now, I may be overextending that a bit, but that was, to me, the original quality enhancement program. As the peer review program has started to advance, there's been changes that have made, and different things have happened over the years. And we've gone from, like I said, we've recognized whether or not it's failure or whether it's failure to remediate. And you've got to make those distinctions. And some of the regulations and some of the rules you have may or may not make those distinctions. Again, going back to the original my thought process, and when I followed it, looking at the 2 failed reviews to accelerate on a third, you're still talking, a firm could function for 3 years, go into a peer review program, fail, 3 years later, fail again. That's 6 years they're out practicing, and if you didn't accelerate them, you'd have them out there 9 years before they did a third report. That was our original thinking. I'm not saying that that's even close to what we should be doing. The regulation there, or the responsibility to the public out there may be different, that maybe 2 failed reviews is excessive. That's why this conversation, as I envisioned it, was to talk about what to do with failed reports. You may not want to accept 1 failed report. As a board member, you may want to jump on a firm that has a failed report and actually take a look at that and see what level they failed. Did they fail because of an inconsistency with a SARS or with some other minor, if I said minor, it may not be significant, but at the same time, in the way the rules are written and the way the program is put together, it's a failure. But is the failure egregious? Is the public not served? Is it gonna not protect the public in any way? And I don't know the answer to that now. I thought I did when I helped say devise the regulations that I thought for New Jersey. I thought we did a pretty good job. I really did. I sat back, took a look at it, and I said, we really broke our back on this. Took a long time to get it done, but I thought we had a good product. And as I've read it the last couple of days, I'm beginning to have questions as to whether or not it's adequate by today's standards. And that's what I think you have to recognize, that what was good yesterday and what the way we looked at it yesterday and what we had may not be what we need. Oh, you had your hand up. Go ahead.
Yes, I'd like to ask NASBA if they would put together a document for the state boards, knowing that most state boards are short-staffed, that list each state and all of their various things, how many members in their prog, are they funded, do they pay them a fee, what do they do with this, what do they do with that, so that, because I don't have the time to go out and look at every state, but if I had it all compiled in one place, that would help us do what we need to do better.
We did do a survey back, it's been probably 6 to 8 months ago. I can't remember exactly when. I shared with the group that came in, that's the new group, in that we will get the results of that survey posted on a website, and we will let you know where that's going to be. All of the information may not be 100% accurate, because as we were discussing in the group, one question we know by one state was not answered correctly. I mean, that happens. We don't know who responded, whether it was an executive director or the PROC person or whomever, but I'm not picking on anybody here. But we discovered that one answer to one question was erroneous. But I think overall it's a pretty good document, and it will let you know how many states, approximately how many are on each PROC by state, tells you which states, and that might give those of you that need that kind of information the opportunity to be able to call maybe that state and say, what are you doing on this? I noticed that you did this a certain way, and I'm sure that they those states would be helpful if they could be. So hopefully that will, as far as the failed reports, we don't really have any specific guidance put together. That might be something that we might get Leona at NASPA to work towards, that perhaps we send out some information and specifically ask boards to respond exactly what they're doing. That was the purpose of this session, is that the Compliance Assurance Committee doesn't know what each state's doing, and that's why we wanted to have this session to kind of see if we can find out. And I think what I'm hearing is that there are really not any, just maybe Texas has some good guidance. I think Mississippi does. Oklahoma has FAIR, but we're in the process of revamping that. We were coming to this session today to hear suggestions and hoping to take some of those back to Oklahoma to where we might work on what our PROC has been doing. So that may be something that NASPA might try to put together, the Compliance Assurance Committee, for you. So.
Any other comments? Anybody want to go ahead?
Yep. Jim, this might be a comment for you or Susan, I'm not sure, but as a state board member, I'm not supposed to see the facilitated state board access report. And what I hear from our executive director, and I can't refute it because I'm not supposed to see it myself, is that the FSBA report has all of the data, but it has no intelligence. That everything you need is probably there, but you have to manipulate it to get to the information that you really need. And again, I don't really have a way of confirming or denying.
Liz, actually hand the mic back 2 tables. Let Colin talk. Colin sees it from, on the Oklahoma side. Let him answer that.
My name is Colin Otten. I'm from the Oklahoma Accountancy Board. My question would be what data, because the FSBA is going to show, like Jim alluded to earlier, who's enrolled, what programs are enrolled in, and a copy of their peer review. The report that you're looking for, what data are you trying to extrapolate? Excellent.
For example, 2 fails in a row.
Yeah, well, that comes in where you've got to have a database system, because right now we can't have both of them on the website. When you get even though it's on the FSBA, it's got an expiration. It will go off. So you've got to gather that data in your own database.
Okay, so just logically, we have a database that's a partial database. We've got to create a database for the database.
Right.
And if I have an expiration date too, neither of us have the information. And again, it's a whole lot of data, but it's not a whole lot of information. It's not the right information that's easily retrievable. Second part of this is he is extremely aggravated that he's got to look through fail reports to determine whether or not the fail is egregious. Oh, you're moving closer. Now I'm scared.
Yeah, well, no,
You gonna hit me?
I thought Colin and I might be having to move
You
back
gotta
and forth.
take
We
it
only have 2
outside.
mics. You want to sit here and we'll all talk in one mic? No, I agree with you about the consecutive fail. That's something I'd like to see us be able to improve on our website. We just haven't been able technologically be able to do that yet. So granted, that's one. Although I will say, if you've had a board requirement for years that you have to submit your second fail or whatever, boards for years have had to somehow track ever since they've had the requirement on their own database anyway. So FSBA is an attempt to make the board's job easier. It's not going to do the entire job for the board. Now, the comments you just made about an egregious fail, I kind of have a problem with an egregious fail. A fail's bad. A fail is a fail, and it's really bad.
Exactly.
What you do have, though, on the FSBA, and this is what I was trying to see if Colin would allude to, is you do have the remedial action. You do have, what was the cause of the fail, what was the significant deficiency, and what the RAB has required the firm to do to remediate. And then you can monitor to see whether that's done. And that's where I was getting at in terms of this is what they're able to use. And my question is, okay, then what more is needed. That's where I'm asking.
Well, again, I think you and I are on the same wavelength, which is he looks at a fail and says, that's got to be egregious, or why else is it a fail?
Okay.
And then what he sees is a constant, you need more CPE. And he keeps coming back to me going, how is it possible that all we need to do is for a remedial action, tell somebody to go get more CPE? And I go, that's because none of our fails are that egregious.
And what I would then go back, and Janice maybe ought to be saying this instead of me, that is why we encourage PROCs who would have the access and the visibility into the RABs to be able to say, okay, in those fails, is CPE appropriate? And if they're consistently seeing that a RABs are requiring CPE and they think they need to do more, that's the PROC's responsibility to go to the board and say, we don't believe this administering entity's RABs are giving appropriate remediation.
Okay.
That would be the job of the PROC to do. And I can assure you, before that happened, there'd be a lot of other discussions to make sure it's being done properly.
Right.
But I mean, we'd have other discussions. But that's the role of a PROC.
Well, essentially, I'm in this catch-22 conversation of we need to be looking at those fails because all fails are important, but then not all fails are important or egregious. And I sort of feel like I catch myself in my own argument.
Yeah.
You
Well, I mean,
also-
I believe all fails are important. It's just a matter of is the system correcting the underlying problem with the firm so they don't repeat.
Let me address, if I could address one thing real quickly.
Go ahead.
Egregious, when I think what I'm seeing when I think of egregious is a firm who didn't do a proper job of planning. They didn't understand a risk assessment. They didn't fill out any kind of documentation about client acceptance. They took on this yellow book engagement without having any idea of what the requirements were. Or they took a Department of Labor, they took an ERISA audit. They had no idea. They got no CPE regarding it. They didn't have any kind of practice aids to assist them in ensuring that they followed professional standards. The report was totally blown. They don't have the appropriate disclosures, and they fail because of that. Now, I've got another firm that failed, and maybe their fail was because of a couple of items, but they are critical items. Maybe their testing of the ERISA wasn't adequate. Maybe their testing of the A133 items based on and I don't do a lot of that work, so I can't remember. It's the guide that they compliance testing. Thank you. They failed also, but there's a little difference in that firm that I first mentioned that didn't have any kind of documentation virtually, and this firm that they failed. It's two failed reports, but I consider the first one pretty egregious. I mean, that's a firm that just really had no clue what an audit was. I'll tell you another example that we've seen in Oklahoma, and these guys didn't even get the peer review, so peer review didn't even enter into the problem, but they did a one-off. They went and did an audit because someone at a church or a PTA or it's just a little not-for-profit organization, they did the audit. They didn't even have a clue they had to do a peer review. So those are the kind of things that I think board members look at as egregious versus and you can look at a response from the firm and make a determination if that firm is going to try to really fix things. And we've kind of already talked about it. I'd like to ask one question, Bob, and I know you need to wrap up, but I want to ask one question because this conversation that's gone on about the information that's available on facilitated state board access versus you having a database. How many boards in this room have their own database to know who is performing audits in their state? So you have firm licensure and they have to attest that they're doing audits. Yeah. So not that many. So how those boards that are not, how do you know whether or not a peer review is even due? And then the second piece of that, for those of you that know through firm licensure, how many of you are matching that data with the peer reviews that you're getting? So really not very many. That's something that we have a little bit of concern about. We had a long discussion yesterday in our Compliance Assurance Committee meeting about whether or not boards are actually knowing whether they're getting the peer review reports they should be. So I think we have some work to do in that area.
I got one.
Okay.
I do have one comment, and this is backing up to the CPE as the follow-up. If you're on an engagement review and all the fail reports you're seeing are engagement reviews, that's basically all the follow-up that you're going to see. So you need to know what kind of review it is, and this again goes back to Jim's comment to where a proc would help, because those folks would know whether that's appropriate follow-up. But you could be seeing a lot of CPE because that's basically what the standards allow for with regard to follow-up on engagement reviews. Not system reviews, but engagement reviews.
All right. Now, just to wrap it up, a couple of things to me are important. One, I think a board, looking at it from a regulator point of view, a board has to have the ability to be able to track as to whether or not its firms in its state are meeting the peer review requirements that they have. You can't rely on an outside agency to do that for you. You can't rely on your society. You can't rely on the AICPA. AICPA told you that they're only going to monitor those people that are members of the AICPA. You're going to miss all the people who aren't members. The same way, if you have a state that still has public accountants that are out there functioning, those public accountants aren't going to be members of a state society. So now, but in combination with what they can provide you with, because your state society can provide you with a list of all the people that are in their peer review program. They can give you a list of the firms. They don't have to give you anything other, but these are the people that we have in our program. That's a great piece of information. It'll knock out a lot of firms for you that you're going to be looking for. You're not looking for the people who comply. You're not looking for the people who are in the program and are trying to make let it work for them. You're looking for the people that are either going to be substantially deficient or that aren't in the program. That's from a regulator point of view. I feel very strongly about that. The other side of the other thing is that the program, like I said, it's remedial and rehabilitative. Let the program function. Let it work. It will work. It will make any firm that gets peer reviewed. I'm absolutely believe this. It makes them a better firm. It makes them a better firm the second time and the third time they go through it. They're going to learn as they go through it. This has been an evolving process over the years. It's going to continue to evolve. Don't use it as a club to beat people over the head with it, but use it to elevate the profession. And thank you.